Hi, I'm Barry Taylor from Equip for Equality. People with disabilities, including older Americans with physical, cognitive, sensory, and mental impairments, have legal rights with respect to accessing government services. Under Title II of the Americans with Disabilities Act, known as the ADA, state and local governments must not discriminate against people with disabilities. This video will provide an overview of the rights of people with disabilities to access government services under the ADA. The ADA covers public services and programs provided by state and local governments, including police and fire protection, state-operated or funded mental health and developmental disabilities facilities, park and recreation programs, employment services and programs, public schools, universities, and colleges, public transportation, state, county, and city legislatures, state and county courthouses, and elections and voting. Note, the ADA does not cover programs and services provided by the federal government, like the post office. However, another law that's very similar to the ADA, Section 504 of the Rehabilitation Act, does cover disability discrimination by federally funded entities. Now, what must state and local governments do under Title II to make their services accessible? Well, first, state and local governments cannot refuse to allow a qualified person with a disability to participate in a service, program, or activity based on that person's disability. For example, a city may not refuse to allow a person with epilepsy to use their park and recreational facilities. State and local governments must make reasonable modifications to policies, practices, and procedures, unless doing so results in a fundamental alteration to the program. For example, a city office building would be required to make an exception to a rule prohibiting animals in public areas in order to admit a service animal assisting a person with a disability. Also, state and local governments must eliminate standards or rules that deny qualified individuals with disabilities an equal opportunity to enjoy their services, programs, or activities. For example, a city could not require a driver's license as the only means of identification necessary to participate in a city program, since many people with disabilities do not drive. State and local governments must furnish auxiliary aids and services when necessary to ensure effective communication. For example, a state could be required to provide a sign language interpreter on the floor of the state legislature. Now, unlike private businesses, which are covered under Title III of the ADA, state and local governments are not required to remove access barriers from each public facility, even if the removal is readily achievable. Instead, the public entity's obligation is only to make its services and programs accessible. Physical changes are only required when there is no other feasible way to achieve this. For example, a public library with books located on the upper floor and inaccessible because there's no elevator may have its staff retrieve materials for individuals who use wheelchairs rather than making the upstairs accessible. Title II also requires the state and local governments provide its services and programs in the most integrated setting. Separate or different programs that offer services or benefits may not be provided to people with disabilities unless the separate programs are necessary to ensure that the benefits and services are equally effective. Even when separate programs are permitted, the person with a disability still has the right to choose to participate in the regular program. State and local governments must also ensure effective communication with people with disabilities. The public entity must provide appropriate auxiliary aids to ensure that communications with individuals with hearing, vision, or speech impairments are as effective as communication with others. Some examples of auxiliary aids and services include qualified interpreters for people who are deaf, or braille and large print materials for people who are blind. Public entities may not charge a person with a disability for the use of an auxiliary aid. In Illinois, people have 2 years after the discrimination to file a lawsuit under Title II. People may also file Title II complaints with the Department of Justice. However, if a person files with the Department of Justice, the time to file in court is still 2 years from the date of the discrimination. The deadline for filing in court does not change just because a complaint was filed with the Department of Justice. If you'd like more information, please visit the United States Department of Justice's ADA website at ada.gov, or you can contact Equip for Equality at 800-537-2632 or at equipforequality.org. Thank you.